So, hello and good morning. I have Joe Fantini with me. And for people who are just tuning in for the first time, you know who we are. I am Michael Stanisci. I've been in the mass tort world for about 1.5 decades. I work at Demandlane, a company that has been around for the better half of about 4 years for mass torts, personal injury, and Social Security disability. I have been in the mass tort space for specifically about 17 years, helping law firms grow and get better at make better decisions and what they do. And my longtime friend here, Joe. Joe, you should introduce yourself because you are brilliant.
Thanks, Michael. Thanks for having me with you. Really excited about this new opportunity of working together and sharing, some of the information we've learned over the last decade plus with our listeners. But I'm Joe Fantini. I'm the managing partner over at Rosen Injury Lawyers. We focus and handle only mass tort cases, so I have a very unique perspective with my background that I'm sure we'll get into. But excited to talk a little bit today about when you're first getting involved in a mass tort and you're looking at a case, what are you really looking at? What really matters?
Yeah. I mean, the mass tort world itself can be overwhelming. A lot of times, people who are just jumping in for the first time, they'll say it's like drinking from the fire hose. It's so much information. There's so many different multi-district litigation options and projects at any given time. What's a good opportunity? How can I really help my claimants? How can I represent people and position ourselves and all constituents for the best chance of success, like you, the people you and communities you serve, right? So, we've definitely seen a lot. I mean, there's decade-long litigations, varying risk profiles. It can really be this deluge of information. And Joe, what I'm excited about is that you can really kind of demystify what this all looks like and share more, pull back the curtain, share more about how you look at a project, how you look at a tort, and really just kind of what your thought process is so that other people can learn how to underwrite and evaluate an investment they might make in the future. So when you're looking at things, there's a lot of different topics, but let's just break it down one by one. The first one I'm thinking about, and let me know what your thoughts are, is the legal viability. How do you look at the legal viability of a project?
I think right off the top, you made a great point. Each of these mass torts are different, right? We're going to have different defendants. We're going to have different products. We're going to have different injuries. So each one does need to be examined on a case by case basis. But the first thing we look at anytime a potential new mass tort comes across our desk is this case going to be viable? So if you're in a traditional PI practice and you're familiar with car accident or slip and fall cases, you got to look at, can we win this case, right? Is this case going to get kicked out early on a motion to dismiss? So some of the things that we're going to be looking at is going to be the different causes of actions that we're going to bring and whether under the law that we're going to be able to win on that. We also look at, right, the injuries that are caused by the plaintiff. We're also going to be looking at whether there could be potential statute of limitation issues. Could there be potential statute of repose issues? Other issues that we need to look at is, could there be an arbitration agreement that's going to govern this claim? So really the first step is when we take a 30,000-foot view is to say, okay, can we proceed with this case and can we ultimately get past that initial hurdle and beat back that initial argument, whether it's there's an arbitration provision or this case is preempted. And so before we even get into the evidence in the case and whether we can win on that, that's the first thing everybody needs to evaluate. And those 5 points are what I kind of look at right off the top before I think it's time to get involved and invest and try to help these clients.
And there's a lot of nuances to that, right? So like a lot of times it's usually best to ask ask someone like you, what happens if the statute is different in different states? What happens if it's a 510K, or what if there's a preemption conversation happening. A lot of times you guys can figure out ways uh, to navigate that within the legal space. And so someone might say, hey, look, there's a discovery rule, or 510K, stay away, or 510K, we can get into this. So is it better to kind of ask you in those situations if someone's on the fence about whether or not a claimant might qualify?
Yeah, definitely. We're around to kind of answer questions on those, but those are two huge issues, and those are big things in the mass tort world, right? The discovery rule that applies in more than 40 states have some form of the discovery rule where it's you weren't the statute doesn't begin to run from the date you were injured. It's when you knew or should have known you were injured. So in these cases, if there's fraudulent conduct on the part of the defendant where they're concealing this wrongful act, somebody could be injured. They could be diagnosed with ovarian cancer or non-Hodgkin lymphoma, but they have no knowledge. Other cases are harder, like you're talking about the preemption, right? That makes the drug cases harder than a traditional product case. And then the approval process that it goes through with the FDA and the type of device and classification is, some of them automatically are kicked out. So just dealing with these type of cases over the years, those are definitely some things you have to look at in each case, and each case is going to be different. But the majority of the cases, I think we can get by on some sort of discovery rule, absent a recall. That makes it a little bit more challenging. But those are two factors you need to look at in every case. We do that every time. So if you guys have questions evaluating that, reach out to myself or Michael. We're happy to point you in the right direction.
Yeah, and then one more question on that I get a lot, that I actually got right before this podcast was, I'm not licensed to practice in the state that the MDL is consolidated into. Does that prohibit me from participating
Yeah,
on a
good
national
question.
level?
We see that a lot. So MDLs, that stands for multi-district litigation. So it's in federal court. Typically, you're admitted to practice in a specific federal court. But usually, when there's MDLs formed and consolidated, the judge usually waives that requirement that you would have had been admitted in that specific court. So that then allows you to do the direct filing the complaints. If you have to do some sort of motion, you're allowed to do that. So that's not an automatic disqualification. Sometimes you have to take a course on the local rules in that specific court, but not a hurdle people need to really be worried about at all in terms of the MDLs.
Love that. Thank you so much, man. It kind of goes right into the next part of the process, which is, the science, right? I mean, this is a difficult part because a lot of lawyers, they didn't go to med school, they didn't study biology, they didn't study, human physiology and different effects. So how do you distill this down into a very easy to understand process? Like, what is your approach when you look at a project to go, okay, I like this science, I don't like this science. Like, what are you looking for?
Yeah, so each one of these cases is going to come down to the experts. It's mass torts is really means battle of the experts. So, because we're involving claims that involve products, we're going to need to put forward our experts to pretty much say how these products were defective. We'll talk about failure to warn in our claims as well. But you really need strong experts in these cases, and the majority of the cases are going to go through a Dahlberg examination. So after you get past that legal viability and you say, hey, we can win on statute of limitations and preemption, the next thing we need to win on is going to be the Dahlberg ruling. Is our expert going to be permitted to testify in front of the jury? So you're going to need to look at what was the reason and the triggering event in the litigation. So was there some sort of recall? If there's an FDA recall, that usually signals there's a serious problem, and those cases seem to be stronger. But if it's just a study that came out, for me personally, maybe one study wouldn't be enough for me to bet the firm and get involved in a case. Typically, when we see a study, we see a couple studies follow that in the years following, and then throughout the life cycle of the case, more studies come out, or there'll even be summaries of cohorts of different studies that summarize all of the different ones. So for me, typically, one study usually isn't enough for me to end up spending a significant amount of time and resources in a case, but you'll usually hear, hey, we're waiting on this next study to come out. Another thing that, in terms of science, can help is when you see the label change, right? So we could have the FDA recall. A lot of these are products, they have a black box warning. When that changes or the label gets updated, that's another strong indication that the science is going to be on our side. But when you're just relying on these, studies, my rule of thumb is one usually isn't enough, but you'll see some excitement when a new study comes out. Typically, I wait for that second or third one to come out to really validate it. And what's important is to look at that study yourself, get a copy of it and read it and see how many people were involved in that study. Was it under 100? That's going to be really tough to rely on that. But when you get the number of patients that were studied, 10,000, a couple thousand plus, that makes it stronger evidence. So that's a huge issue. And the balance of the case always hangs on whether or not our expert's going to be able to come in. So it's going to be a little bit risky, a little bit stressful until we get past that Dalbert ruling, because the defendants bring them in every single case.
That's interesting. I mean, the Daubert ruling, it's also called Daubert from some areas of the United States. Let's dive into that in 1 second. I actually wanted to mention to somebody for fun, in case people wanted to participate before I mention it. But one of the biggest first black box warnings was actually cigarettes. That was one of the most massive changes in our legal sphere. So I'm gonna take it back for a moment, because you mentioned a few different really key pieces in a litigation, right? The Daubert, you mentioned some different processes throughout a litigation. So maybe you can walk us through just for a moment of what are different phases, like what's an emerging litigation? At what point does it become more of a litigation stage? And at what point is it more of a settlement stage? Like, where does Daubert live in that process? And maybe just for a moment, like, what is Daubert? What is that causation kind of conversation, that correlation conversation?
Yeah, so Daubert is just basically the legal standard you have to satisfy in order to get the expert admitted to be able to testify at trial. And so what happens is the judge, they serve as the gatekeeper. And what they do is they evaluate the opinion of the expert. And one of the factors they look at is this a scientific or specific knowledge outside the usual scope of what the juror has. And then they look at, what was the methodology and the reasoning that the expert utilized in reaching their opinion. The judge isn't supposed to make the ruling based upon the opinion of the expert, but more so whether or not a similar expert presented with a similar question would evaluate and look at a case in the same way. So what studies did they use? Did they look at all 50 studies, or did they cherry pick 2 or 3 studies? What evidence did they use? What specific research or testing did they do on their own? Did they look at a very small cohort of patients and limit all of their opinion to that? Or is it really looking at the totality of the evidence presented through the case and the studies, through the depositions, the hot documents to reach the opinion? So the judge does an evaluation on each expert and each opinion. And there's always a lot of briefing involved with that, and then there's hearings, because in mass torts we typically have a couple experts on each issues, and so we'll have a Daubert hearing that will span 2 or 3 days, and then usually we get a ruling from the judge 60 or 90 days. But a Daubert argument, that usually comes towards the end of a case life cycle. So I would say that's about 2/3 to 3/4 of the way done, and once we get past that Daubert hearing, that means that we're headed to trial, right? And so the judge says we have the scientific support to show that, generally speaking, this product can cause this injury we're claiming. Generally speaking, the judge has ruled that Roundup could cause, non-Hodgkin lymphoma based upon our expert testimony and opinion. Whether you can prove that in a case-specific causation. So did plaintiff A, use Roundup and get cancer? That's the next step. But this Dahlberg ruling would apply to all of the cases in the MDL, and it comes usually far down that. And once we win the Dahlberg, a lot of excitement builds in the case. It seems like we're going to get towards trial and hopefully a settlement.
So now you mentioned those trials. Are these the bellwether trials? And maybe like just take a moment and just walk us through, what is the process of a bellwether trial? Like, is it the end all be all? Is it a good indication of where a horizon is going to go? Maybe just take a moment on what those trials look like and what their purpose is.
Yeah, a bellwether trial is in essence a test case. So in mass torts, there could be thousands or tens of thousands of cases, and it's impossible for the parties and the court to utilize resources to have every single case worked up for a trial ready case. So instead, what we do is we go through this bellwether process where the idea is to take representative cases of the entire inventory, which has the facts, the science, and the issue that applies to every case, get those cases worked up like you did in a one off trial case, and then get before the trial judge, get in front of the jury, have the jury speak, and then they'll give their opinion on the value of the case, which facts they believed, which ones they didn't, and you get a feel for how strong the cases are. But how the process usually works is towards the beginning of the case, maybe 3 to 6 months in, you agree upon a bellwether process. And what we've seen now is there'll be some cases selected by the defendants that they think are representative of the inventory, which maybe the plaintiffs believe are a little bit weaker cases. And then the plaintiffs will pick a group of cases as well that they think are representative, which I'm sure the defendants say the same thing, that we're cherry picking the stronger cases. And then a lot of times now we have the judges coming in and they're selecting random cases. So neither side gets the opportunity. And then those cases get worked up like you would, and we'll do fact specific discovery. We'll do depositions of the plaintiffs, of their spouses, of the treating physicians. And then we even move on to the expert case specific causation in each one of those cases. And along the stages, we're kind of chopping the inventory down from initial batch of 50 to 30 to 10 trial ready cases. And then it's kind of flip of a coin, which case goes first for trial. And then the idea is you get a verdict. If that doesn't lead to a larger settlement, the next case is worked up and ready for the second bellwether trial.
So that's very important, right? So this is a situation that if you're just getting involved in mass torts, this is kind of why you want either a mentor or someone with you in the process. Because if you have someone, a person that's hired you for representation, or they're trying to hire you for representation, criteria and intake are so important at that level. Because if you take on a case and you file that case, and it was not really it's not really a strong matter, that could potentially be picked out by the defense. And while you had all good intentions, and there might still be reasons you want to do that, if it's not a good case and it's not a strong science and everything's not together, you could potentially have this trial go up there to the bellwether as an example of what all of these individual cases look like, and all of a sudden you have a poor situation for the plaintiff bar. And so it's really important to run these filed cases by someone like Joe, just so that they can go, hey, look, this kind of fits the mold for what we're looking for in the right kind of criteria and what a good example case looks like. Maybe go into plaintiff numerosity for a moment. I know it's kind of an interesting term, and it's an area that in marketing is really important, because it's really how many people are impacted, right? So in these mass torts, they're consolidated under 1407, right? The JPML is consolidating them because they're like, hey, there's a lot of cases that, while brought as individual cases, they all kind of fit a similar pattern, a similar injury profile. They have unique stories, and so they're all going to be represented differently, but they have a unique injury profile. So how important is it to have, or what are the impacts of having a large amount of people who were potentially impact. It's called an adverse event a lot of times in this industry, and developed the cancer or had a broken medical device or whatever the signature injury is. How important is it to have a large volume, or what does it mean when a lot of people have that injury versus not a lot to you?
Yeah, so it's a really important factor. And like you mentioned, one of the factors that the JPML, the Judicial Panel of Multi-District Litigation, considers when whether or not they're going to form and consolidate these cases into an MDL is numerosity. Usually before the panel, we need to see more than 25 cases to get an MDL formed. Typically, 25 cases, I wouldn't consider that a mass tort. But when I'm looking at these cases is you really want to see the numerosity. So you want to get a feel for what's the total number of potential plaintiffs that are out there, right? So how many people were implanted with this medical device? You can pull that data and get that. How many people were prescribed this medication? You can get that information. How many people are diagnosed with a certain type of cancer each year? You can get that information. And then from there, you need to see, right, how many of these potential plaintiffs were exposed to this product and had the negative kind of impact. But a huge factor, and what you really need to remember is even the people with the injury and even the people with the potential claims, 100% of them don't come forward. I've typically seen that the number is maybe down to single digits. Only 8 to 10% of the people that do have viable claims end up coming forward. So if you want to get to a mass tort that's going to have 10,000 plus people, you're going to need 100,000 people that have this injury caused by the product. So if you're dealing with a product that was only prescribed for a short window or a product that was only implanted in a small number of people, it's probably, from my side, not a case that's going to have that numerosity in there to get, a lot of excitement and a case to really invest your time and resources to best serve your firm and also your clients.
Yeah, yeah, and from a marketing perspective, right? And this is a lot of these factors that we're going to be talking about, really kind of culminate into what an acquisition of a viable claimant might look like. And so when you're looking at a project and they don't have a lot of individuals who are harmed, it's going to be very difficult to acquire those people because you have to raise awareness. A lot of your marketing campaigns are raising awareness, as Joe was saying. And so you have a situation where if only 8 to 10% of people are actually going to move forward on average, right? You can have more or less in different situations. Then you really should factor that into whether or not you wanted to get into that tort. Now, before we go back into the stage of litigation, two more factors really curious about. One of them is the actual defendant, right? So, how do you look at a defendant, at a potential defendant? We have to go to them, and a lot of times you can't make change, right? You can't get a warning on a label. You can't get a product removed unless you have a financial impact negatively to that defendant. And that's also going to be the way you get your claimants paid. So, how do you look at a defendant in that aspect?
Yeah, that's a key point, right? Is the viability of this defendant, right? Is this a defendant that potentially could be facing hundreds of millions or billions of dollars of liabilities, and are they going to be able to really survive this? So, mass torts really evolved over the last couple years, even the last decade, I would say, and a lot of these cases now have become bet the company cases. Like these companies are facing potential extinction due to the threat of the injuries that were caused by their defective and dangerous products. It's not because we're doing anything wrong. It's they put this dangerous product out there and now they're being held to a point. So we definitely look at, the market share, the market cap of these different defendants. We look at other litigations they're involved in. We look at whether or not we have the proper defendant based here in the US, or if they're going to be really a foreign based defendant. So we have the Hague Convention and we can work with that, but really trying to hold that parent company accountable if all of their assets are held abroad, that's going to make it much more challenging. And then we also look at it, what's the history of this defendant in terms of defending these mass tort cases? We've come across, unfortunately, some of the same players time and time again, so we know their playbook. Are they going to be fighting us tooth and nail and extending and dragging out this case for a decade plus, or are we going to have some reasonable attorneys on the other side? One big factor that goes into that is going to be bringing about finality of the litigation. So, from the defendant's perspective, if they're still selling the product, if it's still on the market, if it's one of their biggest sellers, that's going to be a lot bigger fight and a lot longer fight because they're still making money off of that product. Whereas if the product's been withdrawn from the market or recalled, we might have a little bit of a sense that the defendant could be a little bit more reasonable because they're still not depending on it for resources. So we also look at, where the defendant's home, right? What state are they in? What type of laws are going to be applied potentially to these different claims? Are they in a really consumer friendly state, or are they going to be in a really business friendly state? Those are all factors that you have to look at with the defendants. And even if you satisfy some of the earlier factors that we're looking at, right? Even if you have the legal viability, you have the science on your side. If you look at the defendant itself and it's not going to be standing and it's not going to be able to withstand this litigation, it might not be the right one to get involved with.
So you just touched on a really important part, and I'm so glad you did. The venue. So how is a venue, if you want to talk to me about that actually, how is a venue selected? And then how important is it to you where the venue is, who the judges are? Uh, what about the venue is important?
The venue is huge, right? So the venue is going to allow us to have different judges, and depending upon the state, depending upon the court, that's going to shape the rulings. Of course, we can appeal them up and go to higher court, but that's more time, that's more expenses, that's delaying justice for the client. So the venue where the court is going to be huge. So typically in the JPML, when we file the petition for consolidation, we recommend and suggest a court where we want the case to be sent to. And then the defendants, they usually oppose that and are suggesting another court. So maybe some states that have less favorable laws potentially to plaintiffs, like New York, that's maybe where the defendants want to go. And you'll see a lot of times good consumer law states that I would say potentially California will try to get the MDLs out there. So having the right venue is huge. And then also, in addition to the federal level, the MDLs, we also have state court levels. So there's an option to have these litigations in state court. Obviously, over history, everybody knows that federal court is more favorable and friendly to the defendants, to the corporations, to the ones with the money. So when you go into state court, they can try to remove the case up to federal court. If they're able to do that, they will. But sometimes we're able to get the cases in some state courts across the country that do these consolidated actions, like New Jersey or Philadelphia or California or Missouri. But most of the time, the mass torts are venued in federal court, and then it's just going to come down to that judge. So that's a huge issue. You want to consider that. You won't know that right up front when the litigation's getting started, but as time goes on, you'll see who the judge is and get a sense for some of the rulings. And we even see the same judges time and time again. So we know from experience what issues, maybe we'll be successful on, or some other points we're really going to have to dig deep into the discovery to survive.
Amazing. Amazing. So we have a situation right now, right? So you went over legal viability, science, the plaintiff numerosity, the venue, the defendant, and just as importantly, you went over the stage of litigation. Now, here is the money question, right? When you're looking at when you are going to actually get involved, do you have a preference, or are you weighing all of these kind of equally? Like, are you getting in early, assuming the science is going to be there based on what you've evaluated? Are you getting in kind of later stage after Daubert, or are you getting in late stage when the bellwethers are already happening and right before some sort of potential global resolution? Or is that not the right way of thinking about it? Is it kind of fluid?
That is the right way to think about it. So it really comes down to your own risk tolerance. It's like a stock price, right? In the beginning, the stock it's going to be cheaper, right? But then when it's been around for a year, it's going to go up in price. It's going to go up once we survive that initial motion to dismiss. Then once we get into the discovery and we learn all of these crazy facts or how they knew about this problem or issue for years or decades, then the case builds stronger, and it's going to be more likely that you get a successful outcome for your client. And then the further along you go through Daubert to trial is when the cases are going to get more expensive to acquire. So a lot of mass tort firms like myself, we're the ones that are really getting in at the onset, right? When you hear about the recall, when you hear about the initial study coming out, sometimes we even have consumers call us, right? Like sometimes we learn about complaints from these clients directly, even before we're investigating a certain case. And dependent upon that and the other factors we talk about, a lot of firms do get involved real early, and there's an opportunity to service a lot of clients. You can have a bigger impact that way, but some firms might be less tolerant to that risk because a lot could go wrong up front and a lot less could go wrong when you're 2 or 3 years into the case and it's really already built up.
100%, 100%. And so I'm really excited about this next kind of step to what you and I have cooking for something. It's going to be a conversation where people can kind of come in with you on an investment that you're really excited about. If you can tease, I'm not sure if you're willing to tease on this, podcast or not. What are just, your top one or two projects right now, not to put down any other tort that's out there, but what are you really looking at in the next, 1 to 2 months?
Yeah, so I think what we're trying to do here is really just help as many people as possible. So the more we're able to share our knowledge and our experience, it will allow more law firms to get involved, which ultimately helps more clients get justice. And that's really what we're about. But right now, there's a lot of projects going on. Typically, my firm's involved with, 8 to 12 cases at a time. But right now, two of the cases I think that have a lot of excitement, a lot of momentum building, are the social media addiction cases. We have a trial going on, the first trial out in California right now. It's the trial of the year. Everybody's talking about it, whether you're in the legal community or not. This is a huge issue for everybody to really help our children and make a difference. And then the other case that I really like and I'm excited about right now is this hair relaxer, the chemical hair relaxer causing these certain type of cancers. So that case is really mature along. We already have more than 10,000 cases, which is a big number, but there's more people out there as these products has been on the market for, decades. So those are two cases that I'm really excited about, happy to share a little bit more with the people about what I've seen, what we've learned over the years, and they're not super risky. I didn't just get an FDA alert about them today. They're more mature, so getting in towards that tail end a little bit of the litigation.
It's amazing. It's amazing. And so the end of this month, we're going to have a webinar where we jump into those two torts and deep dive. But you don't have to wait till the end of the month. There's actually going to be a conversation, if you're down for it, next week where we can actually use some of this methodology, and you can tell us why these are projects that you're really interested in. Mostly because we can help a whole lot of people, right? And it's an area where you feel very confident that all the different factors of underwriting are aligned, and it's going to be a place where a firm can be successful. And working through you can remove some of that barrier of entry and that, mystical scariness that comes with jumping into a mass tort, because you can actually help educate someone. And if they so desire, they could actually co-counsel with you and work with you and join in with you on these projects.
Yeah, there's a lot of opportunity for people to get involved. We know there's a lot of reasons why people are hesitant, but I think this is going to be helpful, us just sharing a lot of what we learned over the years, and then we'll ultimately be able to better serve the clients. And the more people we have in the fight here, the better it's going to be for everybody.
That's amazing. And I'm so excited about next week for doing that conversation. I'm very excited about the end of the month. How do people find you in the meantime, Joe?
Oh, I think a lot of people follow me on LinkedIn, so if you're active on there, give me a follow, send me a connection. Would love to connect with you, or they could just reach out to me at Rosen Injury Lawyers, or you'll see me on the circuit tour hanging out with Michael.
What is your hashtag that you like to use again?
Oh, Joe does law.
Joe does law. So if you type in Joe does law, if you can't spell Fantini, which is pretty easy to spell, but if you can't, type in Joe does law right into LinkedIn and you'll see his beautiful face. And if you wanted to follow me as well, it's Mass Tort Michael. And we will love to see you on the circuit. And we look forward to seeing each other and all of you join us on a podcast next week. And hopefully also on that webinar. That webinar is going to be stock full of information that is going to be a deep dive, and you'll really be able to understand the scope and the horizon and why this is something that we believe in, together so enthusiastically and so genuinely, is because we think we can actually help a lot of people, and that's, a way of being better together. Any closing parting thoughts before we head off and sign off?
Yeah, thanks for having me. I know it was a lot, but in this series, I know we'll continue to break down these in more details. But reach out to us if you guys have any questions or need any information.
Sounds good. Sounds good. Well, thank everybody. Thank you everybody for watching. Thank you, Joe, for joining, and we'll see you next time. Love you guys.